In this video, we're going to be talking about the case of Adams v. Lindsell. Now, this is another old-timey case from England, and it articulates something called the mailbox rule. And the mailbox rule is sort of a relic of the law, but it had a pretty big importance in the time period that it was articulated. And basically, it was important in an era where people were making time sensitive contracts without a method of instantaneous communication. Obviously, nowadays there's a lot more forms of instantaneous communication, so the mailbox rule doesn't play as big of a role in contract law as it once did. But you can imagine some situations, such as stock trading, where even the instantaneous forms of communication might have a lag that, puts a lot at stake. There's also, of course, issues even with instantaneous forms of communication. Sometimes emails get delayed in being delivered. Sometimes text messages get lost in space. So the law needs some way to resolve these contract disputes where there is a delay in between the time that sort of contract actions are sent and the time that they're actually received by the other party. And that's what the mailbox rule does. So let's jump in to the facts of this case. And we're going to create a timeline here. And this case sort of starts on September 2nd, and that is when Mr. Lindsell sends an offer by mail to Adams offering to sell some wool. So this 9/2 is when an offer is sent. Okay. And Lindsell is expecting that there will be, of course, some delay between the time that he, sends his letter and the time that it gets received, and then, some additional delay between the time that Adams responds and the point where Lindsell actually receives the response. So he is anticipating that he's going to receive an answer to this contract offer by 9/7. So this is when the answer is expected. Now, unfortunately, Lindsell, when he is addressing the letter to Adams, he misdirects it, and so it actually gets delayed in being delivered to Adams. And so Adams doesn't actually receive the letter until 9/5. This is when the offer is received. But Lindsell, being very diligent, he quickly responds, and he actually responds the same day. He says that he received it at 9/5, and then sends his answer that evening. And he wishes to accept the offer, so he sends in the mail an acceptance. So this is when acceptance is sent on 9/5. Um, And then, even more unfortunately for Lindsell, when Adams sends his letter, just because of where he lives, the letter has to go through sort of an indirect route, and so it takes a while for it to ultimately be delivered to Lindsell. So Lindsell doesn't actually receive this letter until September 9th. So this is when acceptance is received. And so Lindsell, having expected to receive this letter, this acceptance letter on 9/7, and having heard nothing from Adams, assumes that Adams doesn't want to take his offer, and so Lindsell ends up selling the wool on 9/8 to a third party who is not Adams. So the 9/8 is when the wool is sold, and then when Lindsell receives Adams Adams's acceptance letter on 9/9, he doesn't obviously have any wool to sell, and so he's not able to deliver. And then Adams sues Lindsell for breach of contract. And so the case goes into the English courts, and Lindsell basically argues that the contract offer, um, he was expecting an answer by 9/7, so he sort of puts this time period of an open contract between 9/5 and 9/7. And 9/7 is sort of the time period where, Lindsell believes that his contract expired. So he was free to sell the wool on 9/8, and the acceptance letter that Adams sent on 9/9 was not effective because the offer had already expired. The court obviously does not go along with Lindsell, and the court ends up identifying that the offer was accepted on 9/5 when Adams sent his acceptance. And this is essentially what the mailbox rule is saying, is that the acceptance is effective when it is sent to the offerer. So as soon as Adams posted his letter of acceptance on 9/5, that was when it was accepted. It's not accepted on 9/9, and the court actually says that this moment where Lindsell receives acceptance is sort of immaterial to the formation of the contract. This is the moment on 9/5 when the acceptance letter is sent that a contract is formed, and at that point it became irrevocable, and Lindsell was in breach of contract when he sold the wool to another person on 9/8. Now, the court offers a few different reasons for why acceptance needs to be effective upon being dispatched rather than being received. And it notes, which I'm not sure is a very convincing argument, but it offers sort of a slippery slope argument that says, look, if we require everyone to have notice of when the other side receives our letter, then we would never really be able to form a contract because you would just have to be sending notices back and forth about when we received the last notice. And so the court, basically, approaches this problem and saying that at some point there needs to be a contract formed, and you're never going to have perfect notice to both sides. But ultimately, where there is a meeting of the minds is at this point where the person who receives the offer sends their acceptance, and it's not necessary to wait until the other party receives notice of the acceptance. But the more convincing logic of the mailbox rule is sort of that the person who sends an offer, and specifically someone who sends an offer by mail, is in the better position to anticipate and accommodate the risk that they are going to receive delayed notice of a person's acceptance. And after all, Adams in this case may have not even known that Lindsell was going to send him an offer, but he answered very quickly and answered about as diligently as anyone could have hoped. And it was sort of Lindsell who was responsible for not anticipating the potential for delay. So now that we've talked about Adams v. Lindsell, let's dig more into the contours of the mailbox rule. And so I want to start just talking about what is the general rule of contract negotiations, and that is that these contract actions, so offers, acceptances, revocation, and rejection. So these sort of four main actions that we take with regard to contracts. Um, the general rule is that these are all sort of effective upon receipt. So for offers, it's kind of obvious because you know someone can't really respond to an offer until they've received it. So the offer, just sort of by logic, offers are not effective until they're received by the party whom they're directed. We also saw with revocations in the last couple of cases, the Evertight Roofing Company and then Dickinson v. Dodd, that the revocation also takes effect once it is received by the other parties. So in Evertight Roofing, the Evertight Roofing Company came to the job location. They had not been told that the offer had been revoked, and so the court basically said that the revocation wasn't effective. And then you had the opposite in Dickinson v. Dobbs, where Dickinson received notice that Dodds had already sold the property to another person that constituted a revocation, that he received notice of it, and that is what killed the offer. Um, we haven't really talked about rejections, but you can think just logically. There's no reason why a rejection should be effective at any point other than when it is conveyed to the other person. So this is the general rule, and then the mailbox rule is an exception to this rule. So the mailbox rule is really an exception to the general rule. And that says that specifically an acceptance an acceptance is effective upon dispatch. And that's what Adams v. Lindsell stands for, is that notion that once you send your acceptance, once you put it in the mailbox, and put it into the stream where it's going to be delivered to the other person, that's when there is the meeting of the minds. That's where we have mutual assent. That's where the contract is formed. And it doesn't matter that the acceptance is not yet received by the person who made the offer. That this acceptance, by beginning the process of notifying the other person of acceptance, that is when the contract takes effect. But of course, there is an exception to this exception, and that is if rejection is sent first, then acceptance is effective upon receipt. And this sort of makes sense if you work your way through it. You can imagine if someone who's really indecisive, they receive a contract offer. At first they think they're going to reject it. They send their rejection letter, and then they change their mind. At that point, it makes sense that you're going to expect that person who sent the rejection letter to go beat the mailman to his destination and not just rely on the mailbox rule, especially when you think about the fact that the person who sent the offer if they receive your rejection before they receive your acceptance, they may take action based on the fact that they received that rejection. Um, and then they'll be put in a pretty difficult position if they relied on your rejection letter and you try to argue that, well, you actually accepted the contract offer a while ago, but you had just sent the rejection letter first. So in that scenario, if you send your rejection letter first, then it's just a race to see which one gets to the person who made the offer first. So now that we know the contours of the mailbox rule and more importantly the general rule, let's work through a couple scenarios. All right, so our first scenario, let's imagine that we have an offer sent, offer received, and then after our offer is received, the person sends their acceptance, so acceptance sent. And after they send their acceptance, they change their mind and decide to send a rejection. And so both the acceptance letter and the rejection letter are sort of in the mail, and then at the end of the day, the rejection arrives first. And then after that, the acceptance is received. So let's see if we have a contract. So applying our general rule, contract actions are effective when they are received by the other person. So this is the moment that the contract offer is effective. And applying our general rule to acceptance, we would say that acceptance is effective when it is received. However, recall that we have the mailbox rule, so it's not when it's received, it's when it is sent. So this is the moment that the acceptance is effective. And then the rejection is effective upon receipt by the other person. So this is when the rejection is effective. And notice we have the offer being accepted before it was rejected. And so this means that we have a contract. The offer was effective at this moment. The acceptance was effective at this moment. This rejection is immaterial. All of the other events are immaterial. We have a contract. Now let's switch things up a bit. So again, let's say we have offer sent, offer received, and then this time let's say they send a rejection, rejection sent, and after they send their rejection, they change their mind and they send acceptance. And then by coincidence, the acceptance, while both the rejection letter and the acceptance letter are in the mail, racing to see who gets there first. Let's say the acceptance arrives first. So acceptance received. And then finally, the rejection is received. The general rule states that contract actions are effective when they're received. So that means this is the moment where the the offer is effective. Recall that a rejection is also effective when it is received. So this is the point where the rejection is effective. And then acceptance, the general rule would say that acceptance is effective when it is received, but because we have the mailbox rule, we say it is effective when it is sent. However, recall that when a rejection is sent first, that destroys the mailbox rule and we revert back to the general rule. So because a rejection was sent first, we revert to the general rule and say that acceptance is effective when it is received. In this case, since you had the offer was effective at this point, and then the acceptance arrived before the rejection, the acceptance was received before the rejection was received. You had an offer, you had acceptance, the rejection is immaterial. This is also a contract. Equals contract. Okay, let's try one more. So we have our timeline, offer sent, offer received, and let's say they send the rejection first. They change their mind, they send acceptance. As the rejection letter and the acceptance letter are racing through the mail, the rejection letter arrives first. And then after that, the acceptance arrives. In this scenario, recall our general rule says that contract actions are effective upon receipt. That means that the offer is effective at this moment. Rejection, the rejection is, I messed up, this should say received. Rejection is also effective when it is received. That is at this moment. And then the general rule would say that acceptance is effective when it is received. However, the mailbox rule says that acceptance is effective when it is sent. However, the exception to the mailbox rule says that if you send your rejection first, then you revert back to the general rule. So in this case, since we have the rejection being sent before the acceptance, we revert to the general rule and say that acceptance is effective when it is received. In this case, we have an offer, then a rejection of the offer, and then an acceptance of the offer. Because the rejection took effect before the acceptance, we have no contract. Equals no contract. All right, very similar. Very similar. We have offer sent, offer received. And let's switch this around. This time we send our acceptance first. We change our mind. We send our rejection. As these two, as the acceptance letter and the rejection letter are racing to their destination, let's say the acceptance arrives first. And then after the acceptance, in comes the rejection. In this case, the general rule says that the contract action is effective upon receipt, so we have an effective offer here. The rejection is effective when it is received. And the acceptance under the general rule would be effective when it is received. However, because of the mailbox rule, it is effective when it is sent. So that occurs here. Since we have an offer, the offer is accepted, and the acceptance is effective before the rejection is effective. This means that we have a contract. All right. Now we get into the trickier ones. All right. Let's say that we have an offer sent, and then after the offer is sent, they send a revocation. So this time the person who's making the offer decides they don't want to make the offer anymore. So the revocation is sent after the offer is sent. The offer is received. And then the acceptance is sent. So the person receives the offer, sends in their acceptance, and then the revocation is received. And finally, the acceptance is received. All right. General rule. Contract actions are effective when they're received. So this is the moment where the contract offer is effective. The revocation is effective upon receipt. So according to the general rule, this is when the revocation is effective. Acceptance is effective. According to the general rule, acceptance is effective upon receipt. However, the exception to the general rule is the mailbox rule that says that acceptance is effective when it is sent. So this is when the acceptance is effective. You have an offer, an effective acceptance, and then an effective revocation. This is a contract. And this is essentially the facts of Adams v. Lindsell. Offer received, acceptance, offer received, acceptance sent, and then a revocation. Doesn't matter. The acceptance is effective when it is sent. Let's try this one. Offer sent. Revocation sent. Offer received. Revocation received. And then the acceptance is sent. And then acceptance received. So this should hopefully be an easy one. Again, the general rule is that contract actions are effective upon receipt. This is the moment where the offer is effective. The general rule would say that acceptances are effective upon receipt, but because of the mailbox rule, an acceptance is effective upon dispatch. So this is when the acceptance is effective. And the revocation, again, general rule, effective upon receipt. That is this moment because you have the offer, because you have an effective offer and then an effective revocation, and only then an effective acceptance. This means that there is no contract. The revocation occurred before the acceptance. No contract. All right, now we're going to try one more super hard one. We're going to try to put it all together. All right. Offer sent. After he sends the offer, he tries to revoke it. The offer is then received. Acceptance is sent. After the acceptance is sent, he sends rejection. Then the acceptance is received. And then at that point, the revocation is received. And then finally, the rejection is received. Okay, now applying our general rule, offer is effective when it is received. Revocation, according to the general rule, that is effective when it is received. Rejection, effective when it is received. Acceptance, it would be under the general rule effective when it is received, but according to the mailbox rule, it is effective when it is dispatched. So here you have an effective offer, you have an effective acceptance, so this is a contract, right? Well, this is a lesson to not succumb to lawyer brain. Notice, you have the person who makes the offer tries to revoke it, and the person who accepted their offer tries to reject it. Why on earth would either of these two people be attempting to enforce a contract that they have both said that they don't want to be part of? There might be a scenario where a contract forms between these two people, but it would be a really unusual set of circumstances, and you really have to ask yourself if this is really the situation that you're being faced with, or if there might be something else going on.